Let's get started. Dungok, Nildaliwas Lea Nicholas, Wallastagwe Winognila Nagadnujiao Nil Nagut Cook, Waliwan Hamathkuyam Squahomish Nagatalewatos. So, hello and welcome. I am Lea Nicholas-MacKenzie from the Wallastagwe or the Maliseet Nation, specifically the community of Tobic, New Brunswick. And I am a very grateful guest in the shared traditional territories of Musqueam, Squamish, and Tsleil-Waututh, where I live and work. And to start, I would like to invite Dr. Kenneth Deere to start us in the right way with an opening invocation. Please go ahead, Kenneth.
No, thank you, Leah. And I will say a few words in English. I'm not a fluent speaker, but in the Haudenosaunee tradition, when we meet, we always acknowledge all of creation when we meet. So I'll try and do this very shortly and quickly, and take into account that all of us, we all. Everything in the world has a spirit, and we have to acknowledge the spirit and the purpose of all those things in creation. And we start with the very earth that and rocks that we walk on, and that continues to serve a purpose. And also all the plants, and particularly the medicines that grow from that earth, and they all serve a purpose, and we give thanks to those medicines, and then also to all the food that grows, the corn, the beans, and the squash, and all the other plants that grow from the earth. We give thanks for them and the purpose that they serve in creation. And we go on to the larger plants, the trees, and like the birch and the pine and all those other trees, and particularly the maple tree, which we call the grandfather of all trees because it gives us the first harvest when it gives up its syrup in the spring. And then we also give thanks to all the animals, the small animals, the the rabbits and the foxes and all of these small animals, which also serve a purpose in creation, and the bigger animals, the deer and the moose, the bear, and all of these larger animals that serve a purpose in creation. We give thanks for them, for being what they are, and how we use them. And then also we go to the to our feathered friends, you know, the birds, the ones that sing in the morning and give us so much joy, and the duck and the geese, the quail and the partridge, all of these birds that we give thanks, and the eagle in particular, which serves like a messenger to the Creator. So we give thanks for all our feathered friends. And then all those things that swim in the water, that the salmon, the trout, the walleye, the pike, all of these things, the small little crawdads, all those things that swim in the water, we give thanks for them because they also serve a purpose in creation. And we thank them for continuing to do the work that they do. And then after that, we look into the sky. We look at the four winds that bring us the thunders and the rain that replenishes our streams and rivers and lakes, and also the brings the lightning that purifies the air. So we give thanks for the winds for bringing those there, and also we take the winds to take the clouds away, so we can have light and heat, so our crops can grow, and we can and that we can warm ourselves. So we also thank the four winds that it carries on their duties today and into the future. And then we also then look into the sky, and we look at night into the stars, and we thank the stars for the purpose they serve of guiding our way at night. And also we also look at that as where our spirits go when we leave this earth and in our journey, and that's where we're going to when we pass on. And also give thanks to the grandmother moon for that special relationship that she has with the women and with the tides, and guiding us at night. So we give thanks to the moon for the purpose it serves. And then there's the sun, and without the sun, there would be no life. And we give thanks that the sun rises every morning to make sure that that life carries on. And the sun, to us, to many people, represents the Creator. So we give thanks to the sun that it carries out its work and its duty. And I also like to add that we, the human beings, the two-leggeds, that we also are part of creation, and that we have a role in creation, and that we have a lifelong journey to fulfill that role. So we give thanks to all of you, to all the people here, that we carry on our role in creation. And so as we deliberate here today, and in this important discussion on the rights of Indigenous peoples, we make sure we take into our consideration the natural world, which we are all part of. So with these words, I open this meeting. Thank you for listening.
Leewan, Kenneth, thank you very much. I appreciate that. So, as I mentioned, I am Lea Nicholas-MacKenzie. I'm the moderator today for this incredible panel. I'm a member of the Coalition for the Human Rights of Indigenous Peoples, and for those who might not be familiar, we promote the full and effective implementation of the UN Declaration on the Rights of Indigenous Peoples. And so we're here today to talk about that implementation. And before we start, I just want to share some words from a friend of the coalition, a member of the coalition who's not with us in the room today, Paul Joff. And what he said was that it's important to underline the significant and growing role of the UN Declaration in international law in reinforcing Indigenous peoples' inherent rights and their implementation. And I'd also like to quote James Anaya and Luis Rodriguez Pinheiro, who emphasized that the articulation and recognition of Indigenous peoples' rights in the last 3 decades represents one of the most astonishing developments in the history of modern international human rights law. But the challenge always lies with implementation. We've just celebrated 18 years since the adoption of the UN Declaration by the General Assembly. And how are we doing 18 years later? And at the risk of stealing Grand Chief Ed John's fire, I would say, I would like to quote him. He always says the instruments are solid, but it's the processes that need work. So let's get started. I will briefly introduce our amazing panelists before they speak, and of course, they can help me fill in the blanks if I've missed something important. Each of our 5 panelists will have about 8 minutes to answer a few questions, and then we'll go to the audience to take questions. And we're going to ask you to please put those questions in the chat or in the Q&A function. We'll do our best to get to them. But of course, we're all limited to 90 minutes for this webinar. And so I'd like to start by introducing Dr. Kenneth Deere, who just did the invocation. He is from the Bear Clan of the Mohawk Nation of the Ganawage Territory. He's an award-winning journalist, educator, and an internationally known Indigenous rights activist, active in the implementation of the UN Declaration on the Rights of Indigenous Peoples. He holds an honorary doctorate from Concordia University and was the 2010 recipient of the National Aboriginal Achievement Award. As a champion of the right to self-determination, he's also been a leader in enhancing the participation of Indigenous peoples in the United Nations. And so what Kenneth is going to do is talk about the history of the negotiation of the UN Declaration and of Indigenous peoples' participation in international advocacy. Please take it away, Kenneth.
Thank you, Leah. Thank you for that kind introduction. And I only have 8 minutes, so I had a lot to go through in this 8 minutes. So I'll try to do what I can. From the Haudenosaunee perspective, we at the international level, Indigenous peoples have been knocking on the door for a long time, and in our case, we in 1923. Cayuga Chief Discahe went to the League of Nations in Geneva to try to address the League of Nations in 1923 and 24, and he was rebuffed by the League, and he wasn't allowed to address the League, and that seems to symbolize the plight of Indigenous peoples, for the last 100 years, is that we're keeping knocking on the door of at the international level, trying to have a voice at that level. But this guy is credited as being the first person to knock on that door. I'll skip. Even though he wasn't successful, his effort is still recognized today as that starting point. I'll jump forward now to 1977 or the 1970s, when we were still, with the creation of the United Nations, there was still no voice for Indigenous peoples, and people were demonstrating across the street from the UN on First Avenue in the early 70s, because we weren't allowed in the building, and people were demonstrating. So finally, after Wounded Knee and a meeting out in Standing Rock, Indigenous people said we have to take our issues internationally. So they organized, and they got a meeting in Geneva in 1977 called the NGO Conference on Racial Discrimination Against the Indigenous Populations of the Western Hemisphere. And about 200 to 250 Indigenous people from the Western Hemisphere, and also some Maori and some Sami, went to Geneva to attend this important meeting. And here they express to the UN where are our rights? Where are Indigenous peoples? What? Because we're being told that international human rights law does not apply to Indigenous peoples, that we don't have a right to self-determination. We're not peoples, we're populations, we're tribes, we're groups, communities, but we're not peoples. And this was frustrating for our people. So our people there, convinced the UN, you got to do something about this. And then they did a study called the Cobo Report on Indigenous peoples, and they created the Working Group on Indigenous Populations in 1982. It was five human rights experts, one from the five different regions of the world. None of them were Indigenous. In their meetings that they had in 82 and 83, Indigenous peoples asked them to have a declaration on what are our rights, what are the rights of Indigenous peoples. And we had to convince them that Indigenous peoples are not minorities, that the rights of Indigenous peoples are different from minority rights. And so they began a process of drafting the UN Declaration. And in those days, in the 80s, the Indigenous people used to meet for 1 week from Monday to Friday in Geneva and drafting text, drafting articles on those rights. And then the working group was on the second week, and we would give them our drafts and our text that we want on all those rights that you see today, education, on language, culture, land, territory, self-determination, all of those rights. We were drafting the text that's in the declaration today. And it started out when I went in 87, they were 12 articles. And then by the time I left, there were 18. They accepted six more, in 87. And every year, Indigenous peoples convinced the five experts, who were none of them were Indigenous, what those rights were. So that first round ended in 1993. 1993, the year of Indigenous people, with no S on it. And the working group targeted 1993 as the year of Indigenous people, that they would finish the drafting of the declaration. So in 1993, there were 45 articles. And the last article that was agreed to by the working group was Article 3, that Indigenous peoples have a right to self-determination. There was so much resistance to that right. It became a flashpoint between experts and states and Indigenous peoples. But they finally accepted the right to self-determination, and it was passed by the working group in 1993. It went up to the parent body, the Subcommission on the Promotion and Protection of Human Rights. It had a different name then. And there, they convinced them to let it pass without changes, because there were some human rights experts did not agree that we had a right to self-determination. But it was what we got it through. And then it went to the Commission on Human Rights in 1995. Now, the commission is made up of states, state ambassadors, and they hated the declaration. And they created another working group on the draft declaration of the rights of Indigenous peoples. And their plan was to elaborate a declaration within 4 or 5 years. They didn't even in the resolution that created this work. They don't even mention the draft declaration that was passed by the subcommission. They just said they will elaborate a declaration. So they were so much resistance to the draft declaration, and so the battle from 1995 and onward was with states, and very quickly it's a states-run meeting, and so we didn't have a voice directly in that, and we would raise our hands to speak, and the chair might or might not recognize us, and we could see the danger now that they are really going to gut the declaration. So we held a walkout in 1996, and we said we're not going to go back in there until we have a voice. It's a long story, but the chair offered us, they said that as long as you're in the meeting, you can be part of the consensus in the informal part. So we accepted that. And then started the long battle from 1996 all the way to 2006, 10 more years of negotiations on the declaration. And we refused, because we were part of the consensus, we refused to accept any changes in the declaration. And the states got frustrated, but we managed to defend and educate states. Every year we would take a bundle of articles and we argue with them. And while we were arguing, we defended every single article, sentence, paragraph, word, comma. We defended everything, and we educated states as we went along. We couldn't hold them off forever, and they threatened to kill the working group and kill the declaration. In 2004, it was finally broken open. Another story that it can't no time to go into. Then negotiations started in earnest for changes, and they broke us up into two groups, which was also more harder on us. And so some negotiations and some text had to be negotiated during that time. And when 2006 came along, the Commission on Human Rights was being dissolved, and the Human Rights Council was being created in 2006. So this working group was going to die, basically at that time. The chair said, "That's enough. No more negotiations. All the articles that we don't agree to, including the right self-determination, I will decide what will be in the declaration." So now it became a chairman's text, and in that text, he took some things out that we didn't like, but he kept the right to self-determination unchanged in Article 3, which was very important. And all the articles from 25 to 30 on land, territory, natural resources, he didn't change either, because those weren't agreed to by consensus. There are a couple of other things too. But this is his text, and it went to a vote in 2006 in the first meeting of the Human Rights Council, where we were hoping to have passed by consensus, but Canada called for a vote under the Harper government, and they called for a vote, and Canada voted against the declaration. And Russia, hiding behind Canada, also voted against it. But it was passed with a standing ovation. But Canada, what people were calling, states were calling Canada disingenuous by their actions. But Canada wasn't satisfied. The Harper government was still not satisfied. While the declaration was on its way to the General Assembly in the Third Committee, Canada lobbied the African states, telling them how dangerous and how bad the declaration was. So when the declaration went to the Third Committee in New York in late 2006, the African governments asked for more study, which meant they wanted changes. So another round of negotiations took place in New York, where we are not in the room. It's only states who are in the room. So you had the Latin American states and African states, debating over these changes. African states wanted 43 changes, I think, and so we got it whittled them down, I think, to 9 changes. A couple of them had no changes. One of them improved the text, but that's where Article 46.1 on territorial integrity was added by the African states. They redlined that, so we couldn't risk the African states and other states voting against the declaration, and so that had to be agreed to. And then it went to a vote in the General Assembly on September 13th. Is that right? 2007, and where it was passed by 143 countries, I think, and 4 countries voted against: Canada, United States, Australia, New Zealand, all children of Great Britain, and they voted against it. But so we so that's how the declaration was passed. And I can't, I just want to emphasize, being a witness and be part of it, it was a tremendous battle that people put up to get that declaration. Against all odds, against people saying that, well, this declaration will never see the light of day. You had to hear it for your own eyes, how much resistance there was to the declaration. And if you heard that, you would appreciate what it is today, because I really appreciate the declaration. Despite its flaws, it's tremendously, tremendously strong and important. I'll leave it like that. Thank you.
Amazing. Thank you, Kenneth. I learn something new every time you tell that story, and I never ever get tired of it. So thank you very much. It was indeed the longest negotiated and most thoroughly vetted international human rights instrument that the UN has seen. So next, let's go to Chief Francis Laceese. Chief Francis became the vice chief for the South Cotin national government in 2025. He has dedicated a majority of his lifetime to servicing his community in leadership roles. With a keen focus on international relations, Chief Francis has been voicing the concerns of his nation on a global scale through the United Nations with other Indigenous groups. And fighting for the full jurisdiction of the South Cotin lands has always been at the forefront of his work. So what Chief Francis is going to do is talk about the implementation of the UN Declaration in practice through the lens of their title case, as well as an agreement with TASECO as case studies of the exercise of inherent rights and the rights articulated in the UN Declaration. Please go ahead, Chief Francis.
Thank you. My name is Chief Francis Laceese. I am the Chief of Tlaxco, one of the 6 Tlaxcoaltian communities. Sichanalya. Thank you to the organizers of this panel, as well as to my friends sharing this panel with me today. The more we get information about the implementation of UNDRIP, the better off our people will be. Who we are 6 Tlaxcoaltian communities that have been working together as a nation since before contact. And we continue to work as the Tlaxcoaltian National Government, TNG, established in 1989. In 2014, we won the first declaration of Aboriginal title. The Supreme Court of Canada recognized that we own and control all of those title lands. As Indigenous peoples, we know that we hold title and jurisdiction over all of our lands. We need all of our lands to survive. That is why consent is so important. Most of the fights our nations have faced would never have happened if government respected our free, prior, and informed consent. Our title case was brought to court because the government approved clear-cut logging of our force, despite our peoples opposing it. For decades, Tastambi Fish Lake, a very important spiritual and cultural place for the Tlaxcoaltians, was under threat of mining. We had to fight to protect this area on the land and in the courts. Canada actually rejected the mine proposal twice, and then we had to fight in court for years to uphold that rejection. But British Columbia granted an approval for a massive drilling program at Tastambi. Our free, prior, and informed consent was never respected until now. In June of this year, the Tastambi Gagawat-E Tastambi Agreement was signed between BC, Taseko, and the Tlaxcoaltian Nation. This agreement protects our rights of free, prior, informed consent in the Taston area. This agreement means respect. It means safety for our people. This agreement means Tastambi is protected from any mining, drilling, or exploration without the consent of the Tlaxcoaltian people. This agreement should be used as an example of how consent can be respected by governments and industry. In closing, we have been at the table with BC and Taseko for almost 6 years to reach this agreement. This agreement is built on free and prior informed consent that should be the starting point for government and industry. We see governments now trying to fast-track approvals for major projects without recognizing free, prior, and informed consent. But this won't speed up major projects. It will only lead to conflict and disrupt major projects. This will be costly to governments and business. Our war chiefs took a stand against development on our lands without consent in 1864, and we carry that teaching to this day. And we thank you for listening to Chanel. Thank you very much.
Well, Chief Francis, thank you for that. And I just wanted to say that the nation has a project for international Indigenous youth ambassadors. They're making sure that they're incredibly strong young people fully understand not only their human rights in the context of the human rights framework, but they are learning how to advocate for these rights alongside Chief Francis at the United Nations. And that's, of course, an incredibly important thing. So next, we are going to turn to Naiomi Metallic. Naomi's from my part of the world. She's from Listigouge, Mi'kmaq First Nation. She's currently pursuing her PhD through the University of Alberta, and her dissertation seeks to comprehensively unpack how the United Nations Declaration on the Rights of Indigenous Peoples provides a framework for the exercise of self-government by Indigenous peoples with Canada. Since 2016, Naiomi is full-time faculty at the Schulich School of Law at Dalhousie University, and she holds the Chancellor's Chair in Aboriginal Law and Policy. and she's going to be sharing some slides where she's talking about the legal implications of the UN Declaration and the UN Declaration Act, as well as recent Supreme Court and other cases that implicate the UN Declaration. So please take it away, Naiomi.
I'm very happy to be here. Thank you to the organizers, and also thank you to Dr. Deer for both the invocation as well as all the important work that he and many other Indigenous folks did in the negotiations of this extremely important document. So my presentation is going to try to take us through a little bit of an overview of what's been happening in Canada with the Declaration. So as was mentioned by Dr. Deer, initially the Harper government had voted against it. There was some support in 2010, but with some significant caveats. We know the Trudeau government coming in on a platform to implement all the TRC calls to action, one of them being to implement the UN Declaration as the framework for reconciliation. So we get with that Minister Bennett eventually appearing before the UN and endorsing the declaration without any qualifications and saying that this would be a mechanism to breathe life into Section 35. We also saw some policies passed by the Trudeau government in terms of taking on a new relationship with Indigenous peoples, which was deeply informed by UNDRIP. That was the policy. And then we saw with the executive, that was the executive, and with Parliament and different legislatures, acts by governments to implement the Declaration through legislation. And I'll speak to the implementation legislation of Canada in particular, although there's quite a bit of similarities between what Canada, NWT, and BC have passed. And beyond that, there are now several examples of different federal and provincial statutes that do say in their preamble and some of their provisions that they are attempting to apply the substantive provisions within the Declaration. There's debate to the extent whether they're really doing so meaningfully, but there you have it. But I'm going to focus primarily on what's happening in the courts. So it's not that we needed necessarily implementation legislation to use the UN Declaration to interpret Canadian law. There's a long tradition of international human rights instruments being used to interpret the Constitution, common law, statute law, and this is called the presumption of conformity with international law. Even, at the time when the Harper government sort of changed its position in 2010, I would say from then forward, we did see cases where the courts were applying the Declaration in order to interpret Canadian law. Although we got kind of back and forth by different courts. Some would say, well, it hasn't been ratified. That showed sort of a misunderstanding of what the Declaration was. So some called it aspirational. So you saw kind of these different approaches. Probably the most exciting and the most recent is in the 2020 Montour decision from the Quebec Superior Court, where the trial judge relied on the Declaration and the presumption of conformity, as well as the rule that you can take a different approach from Supreme Court of Canada cases, where things are where things are evolving in law and in society, and the judge relied on UNDRIP to say that given those things and the Declaration, she could depart from the Supreme Court of Canada's test in the Vanderpeet case on Aboriginal rights. But there's even further developments with the implementation legislation, and here I'm just going to focus briefly on Canada's. I'm not going to go through this in great depth, but essentially the implementation legislation seems to do two things. One is that this is on the second column, but provides a framework for governments to implement the Declaration, right? And so here we give examples of the Canadian one, but requires Canada to take all measures to ensure that the laws of Canada are consistent, and to adopt an action plan, and to consult with Indigenous peoples in that regard, and there's specifics on what the plan is supposed to look at. But it does more than that as well. There's a lengthy preamble that refers to the fact that the Declaration is affirmed as a source of law, of Canadian law, and the preamble also refers to the TRC's call that UNDRIP should be the framework for reconciliation. And there's also a specific affirmation at Article 4 or Section 4A that says that recognizes that the Declaration is a universal human rights instrument with application in Canadian law. And beyond that, we also have Section 2.3 that says that there's nothing in the Declaration that should prevent it from applying immediately within Canadian law or delaying it. So there's a little bit of, I guess, debate to some extent about what in particular the affirmation means, and we are still in the process of the courts sort of giving us guidance on what that is. There's one school of thought that says, oh, it simply just means that, you know, the governments have to implement the Declaration. But they don't have, you know, we didn't need legislation for the governments to implement the Declaration. So that doesn't seem to be a very good possible interpretation. One is that it's directly incorporating the Declaration into Canadian law and making all its provisions binding and enforceable. That argument was rejected with respect to the BC Implementation Act in a case called Gitsala, but that is on appeal. And there are people putting forward, you know, different arguments that, you know, maybe short of enforceability, there might be, you know, something more going on with the act because of the honor of the crown and the affirmation in it as well. It might be quasi-constitutional in nature. So there's different arguments that are developing. And then there's one that, you know, the third argument, which I think there's a lot of support for, is that clearly the act confirms that UNDRIP can be used to interpret Canadian law, which was already the case, but it seems to be kind of confirming this. And you know, there was some case law in 2020 from the Supreme Court that kind of muddied the water in terms of what types of instruments can be used for the presumption of conformity But in any event, we are now seeing some developments from the Supreme Court of Canada in the Bill C-92 reference from 2024. They said that the effect of the Act was to incorporate the Declaration into the country's domestic positive law. They didn't elaborate much more than that, but in that case, they certainly looked at the UN Declaration and the fact that it was used to inform the legislation as one basis for upholding it. But then in another case from that same year called Dixon, both 8 of the 9 judges used the Declaration to interpret the Charter, Section 25 of the Charter. The majority just kind of accepts that UNDRIP can be used to interpret the Charter. The dissent specifically referenced the presumption of conformity and this Quebec, and said that this was consistent with a previous Supreme Court of Canada case, without getting into all the details of it. And I guess even more importantly, we're seeing you know, in the C-92 reference, the court actually, for the first time, sort of says that reconciliation is a long-term project, and it's about sort of the braiding together of domestic, international, and Indigenous laws. And it's the first time the court has ever gone to say something that far. And so the court is saying things that are creating much more space for international law and Indigenous law and their coexistence with Canadian law. My last slide, I'll just say we're seeing a lot of developments. The Declaration is being cited in all kinds of cases. I had a student do some research. There's about 34 in the last 5 years cases where the courts have actually really engaged. There's a lot more where it's cited, but the court doesn't really do anything with it in all kinds of areas. And some very you know, interesting ones are ones to watch. Kabawik was just at the Court of Appeal and is you know, about FPIC. You know, the recent Cowichan case, UNDRIP was used around Aboriginal title, and of course I mentioned Montour. So a lot of developments. We are very much in a time of transition around how the courts are using the Declaration. Thank you.
Wow, that's an amazing amount of information you just shared with us, Naiomi, in such a short period of time. It's much appreciated. And you used the A word, aspirational, and I want to thank you for bringing that up, because it's so frustrating to me to keep hearing people say that. We remember that in 2010, when the government accepted the UN Declaration with conditions, one of the things they said is that, well, it's not part of customary international law. But in 2012, the International Law Association actually did conclude that certain provisions of the Declaration were indeed customary international law. And also, because it was grounded in self-determination, you could even apply it to the entire Declaration. So that's something I'd love to talk more about if we get a chance to. But next, let's go to Dr. Sheryl Lightfoot. And she is part of the Department of Political Science and the Monk School of Global Affairs and Public Policy at the University of Toronto. As one of the world's experts in global Indigenous politics, Sheryl's research specializes in complex questions of Indigenous peoples' rights and how those rights are being claimed and negotiated in various political spaces. Now, she also serves as vice chair and the North American member of the UN Expert Mechanism on the Rights of Indigenous Peoples, and she's also the past chair of that body as well. So, Dr. Lightfoot, we're going to ask you to talk about Canada's UN Declaration implementation in an international context and the value of international solidarity and collaboration. You have the floor.
Thanks so much, Lea, for the really generous introduction. And I also want to express thanks for the coalition for organizing this conversation today. I'm joining you actually from Wurundjeri territory in the very southeast corner of the mainland of Australia, a city we also call Melbourne, where it is Tuesday morning and it is a beautiful spring morning, warm and sunny. So very pleased to be able to join you from across the Pacific. And thanks, Naiomi, for the really comprehensive but quick overview on the state of jurisprudence in Canada, because I'd like to extend that moment. I think we're at a critical transition moment, as you say, domestically, but we want to situate that in the international context as well. And as Kenneth Deere walked us through, the Declaration was never conceived of as strictly a domestic instrument, although that's a key part of what we're doing. It was and has always been the result of transnational Indigenous diplomacy. And so I'd like to spend some minutes today looking at those global processes that are unfolding, granted quite unevenly across different jurisdictions. So when it comes to an approach like legislation, we can say Canada pretty much stands alone in having enacted a national legislation for implementing the UN Declaration. Now, we can look at Ecuador and Bolivia, who quite early on integrated it into constitutions instead of legislation. But even with that distinction, Canada's national federal legislation really remains a crucial precedent in moving human rights language into a domestic law and policy framework. So if we look comparatively, we can look to the north in Norway, and the Sami people there and the Norwegian government for years were regarded as global leaders with a framework for consultation through the Sami parliament that really once was a role model for many others. However, times change, and in 2025, earlier this year, the MRIP, the UN expert mechanism that I sit on, made some recommendations to Norway that they redesign their consultation framework to align with the UN Declaration's free, prior, and informed consent standard. Now, the Norwegian government appeared on the panel at the MRIP in July 2025 and rejected MRIP's advice outright. And so thus far is resisting any of those recommendations, reminding all of us that political will remains a central challenge in all of these questions. Now, as I said, I'm currently down in Australia, and so I want to point to some interesting and potential innovations going on here. Several years ago, Australia appointed an ambassador for First Nations people, and that ambassador has been able to bring Indigenous rights perspective directly into foreign policy, trade, and multilateral engagement. And most recently, which I learned about in the last few days in more detail, the role enabled a First Nations chapter in the free trade agreement between Australia and the United Arab Emirates, so that Indigenous peoples' rights are upheld in those international trade agreements. And very soon, early 26, they'll be launching in Australia their International Indigenous Strategy, which will help coordinate the global work better on Indigenous rights, development, tariffs, trade, and diplomacy. So I think these are steps worth watching and considering as Canada moves to deepen its international engagement in these areas. Also from this region, next to Australia, we have Aotearoa in New Zealand. And up until a few years ago, there was significant progress here towards a national action plan on the UN Declaration. And then the government abruptly changed course with a hard swing to the right in October 23's election. Both the Special Rapporteur and the MRIP have since received formal country engagement requests from the National Human Rights Institution in New Zealand, together with the iwi Chairs Forum, calling for specifically dialogue and renewed dialogue and continuity in bringing that plan forward. Meanwhile, we've caught wind that Fiji is said to be in the final stages of preparing its own national action plan. So I'll be very interested to see what that looks like when it comes out. Now, in terms of collaboration internationally, I would say from my vantage point on the expert mechanism, I can see how all of this work gets interconnected. MRIP's country engagements in the last few years in places like Finland and Norway and Australia create important opportunities for governments and Indigenous peoples to dialogue and learn from each other and especially hold one another to account. So equally important that we can point to is the role of transnational networks of cooperation. So the same networks that Kenneth Deere was speaking about that produced and defended and negotiated the declaration continue to sustain its work. And across regions, what we're seeing is Indigenous leaders and experts and organizations are sharing information, sharing their knowledge and tools on FPIC, on climate governance, on digital sovereignty, on trade. And these exchanges are happening both inside the UN building and outside. So through MRIP and through independent collaborations amongst this wide diversity of advocates and academics, we're witnessing, I think, a revitalized form of Indigenous multilateralism. We're seeing people work together across borders and across sectors to help shape these norms. So I want to end with a call for Canada in particular. I think Canada, in all of this context, despite its past history, has been in the last decade or so well positioned to show leadership in this space. And I think together with Australia, this has been an important partnership. And Canada's legislation and national action plan certainly indicate a serious commitment to implementing the UN Declaration at home, but it also provides an important platform for continued positive, constructive engagement internationally. And from my observation, one of the key reasons for Canada's leadership in the last decade in the international Indigenous rights space, as I see it, is number one, the strong communication pathways between Indigenous people and the Canadian government that have developed and crystallized, especially in recent years. And as the declaration itself states, cooperation and collaboration together in an atmosphere of mutual respect with Indigenous peoples produces positive results. So I want to encourage that to continue. Secondly, of course, we're in an area where the multilateral rules-based order is certainly under stress and strain, and we all see that. Canada's sustained participation in the UN Indigenous rights mechanisms has played a leading role, and we need to continue to play that leading role and leadership role within the UN system. And then I'd like to suggest that following Australia's example, Canada might consider appointing a dedicated ambassador for Indigenous peoples' rights and developing a comprehensive international Indigenous strategy. And these would be steps that could help, number one, embed Indigenous rights more deeply across foreign policy, trade, development, environmental cooperation, climate change, et cetera, et cetera. But it would also secure that leadership role and encourage that constant communication, cooperation, and collaboration. So this would help us uphold the declaration domestically as well. And as mentioned by Chief Francis, could actually help avoid some expensive and costly mistakes as we move forward. So just 3 points I want to end with to conclude. I think implementation, first of all, is reciprocal. Domestic and international are constantly reinforcing one another. Secondly, solidarity and cooperation remains our most powerful instrument and tool. And thirdly, Canada's leadership in this space does matter. And we need to continue to uphold Indigenous diplomacy and Canada's multilateral commitments. So thank you very much. I hope I didn't go over time, Lea. And if I did, I apologize.
Thank you so much, Sheryl, and I really appreciate a number of the things that you said. Talking about that combined term of consultation and cooperation, which necessarily means that this is far beyond just consultation, but participation in actual decision making, as Chief Francis pointed out as well. And thank you also for that call for ongoing leadership by Canada and the idea of a dedicated ambassador for Indigenous peoples' rights. Something I've also long called for. Canada has thematic ambassadors for women, peace, and security, for climate change, for things that are really important to Canada as a country. And so it makes perfect sense, I think, to go in this direction as well and follow Australia's lead. So finally, we are going to turn to Grand Chief Edward John. He has been involved in the advancement of Indigenous rights and treaty negotiations for decades. From 2011 to 2016, Grand Chief John served as the North American expert member to the United Nations Permanent Forum on Indigenous issues, including serving as chair. Now, he was also part of the negotiations and the adoption of the UN Declaration that Kenneth spoke about. He was Minister of Children and Families in BC, Special Advisor on Aboriginal Child Welfare, currently is the chief in his community, and back on the Treaty Commission. I'm sure I've missed something, but anyway, Grand Chief John is going to talk to us, though, about implementation challenges and opportunities that we face today, and specifically political challenges facing Indigenous peoples' human rights advocates. So please go ahead, Grand Chief. Oh, and I think you're on mute.
I think you're right. Adi, snachas ya di an di tlanautos dil di ni den we had to tell that must see notice ni. I know Francis will understand what I said. We speak the same language. They're south to the south of where we are. I want to thank the coalition for convening this session. I think it's timely. A couple of things. I really appreciate the comments made by all of the presenters so far. I think it's those recommendations that are coming forward are really worth our effort, because this is how we move agendas. The thematic ambassador, as you recall, Lea. We need a resolution that will go to our General Assembly of our chiefs in December that would support something like that. That we would take it to the political level of our leaders across this country. I think the UN Declaration, I really appreciate Kenneth's recounting of the time and effort it's taken. But political solidarity, as Sheryl calls it, that developed a long time ago, and we need to keep that as expansive and as inclusive as possible, that we all have something to share in this. I play different roles in this now. In my communities, looking at how we implement the UN Declaration in our communities in the face of widespread resource development, major projects. You have two documents that I sent to you, Lea, and to Jeremy, which I've asked you could circulate to those who are interested in receiving it. The UN Declaration talks about rights and freedoms. It doesn't stop at rights, but as you go into the text of the Declaration, it talks about rights and responsibilities. Article 25 is very large on responsibilities to future generations. Article 25 is really clear that Indigenous peoples have a distinctive spiritual relationship to their lands, waters, seas, all of that. What is that distinctive spiritual relationship? Well, it comes from our teachings. It comes from our dada, as we call. And inherent in those ancient stories are the responsibilities. The first thing that comes out in all of those legends is the word responsibility that we have to each other and to everything that we live with, wherever we come from. Wanted to say that 2027 will be the 20th anniversary. On 2008, I'm really glad to see Jennifer Preston on this call. We convened a year after the UN Declaration was adopted. We convened a province-wide and invited experts internationally to Vancouver to see what will we do in implementing the Declaration. You should read that book. It's interesting because now you have a sense from those experts from the 7 geopolitical regions as to what they're thinking about, what would the implementation look like. And as we look back in 2027, and we should convene a session similar to that in 2008 to take a look at the last 20 years and where can we go in the next 20 years. I really think that's important going ahead. I think we have momentum on our side. We have political legislation. We have following the UN World Conference on Indigenous Peoples in 2014, there were commitments made by the UN for system-wide action plans. And the idea was to embed the UN Declaration in the work of all of the UN bodies, agencies, and mechanisms that are there. And I think we've seen that. We've also, one of the outcomes of that particular World Conference was national action plans, which when Canada and British Columbia adopted the legislation, action plans were also the next step. How do we action these items, full and effective implementation? And that's still a work in progress. Not everything in the Declaration. I'll tell you something that I think is really important. On the issue of redress, Article 28 of the UN Declaration, it's very important in British Columbia when we talk about redress. The Supreme Court of Canada talks about Aboriginal title as having an inescapable economic component. It means there's a value to what the lands, territories, and resources that were taken in British Columbia by proclamation on February 14th, 1859 by James Douglas, proclaiming that all lands in British Columbia and mines and minerals therein belong to the Crown in fee. February 14th, 1859. From that, the province of British Columbia assumed jurisdiction over private property. And, now we see the result of that private property interests were created, leases through fee simple tenures, leases. And a court case in British Columbia has disrupted that whole thinking, saying what you did was wrong, And so now, how do we look at the issue of redress? My suggestion would be one permanent forum to convene an experts table on what redress is, Article 28, and the expert mechanism on the rights of Indigenous peoples to convene a study on the issue of redress relating to lands, territories, and resources. And how will those support 4 priorities that we have in my community, for example? I'm sure it's the same in other communities. The social economic gaps are very deep. They're widespread. They're pervasive and debilitating to our people, our families, and communities. Secondly, would be the infrastructure gaps, including housing. They're again very deep, very pervasive, and we have to deal with those. 3, the cumulative effects that we see in our lands, territories, and resources and how it affects our peoples. every day, and people and fishing and people and hunting, and what we find out there. We're pretty much like in the prairies right now in the territories where I come from. And the last one important is the whole capacity development, starting from our babies, our young ones, daycare, all the way up to our language teachers, our academics, our engineers. And Naiomi, thank you for doing the work that you do. And because I see the thinking that you put into your work and how the courts have adopted that and accepted that. I think the three threads woven together, I think, are absolutely essential. And thank you for your wonderful thinking this. And this is what I encourage our young academics and our young professionals to look beyond the status quo. There's too many of our people are just stuck in the status quo. We have lawyers that say, oh, consultation and accommodation. What the UN Declaration does, free, prior, and informed consent, it sets a threshold that we are governments and the ability of sovereign entities to make decisions with respect to our peoples, with respect to our futures, with respect to our lands, territories, and resources. And it's not just about governments and industry consulting with us, Lea, as you said. We have governments and Indigenous peoples who can make decisions affecting our future and affecting our lands, territories, and resources. Given that we're faced with a major nickel mine deposit across the river from one of my villages, 10 kilometers away, and an LNG pipeline right next door to the village, two major projects. How will this impact our people? How will we see our future with a mine that is being proposed that will be with a tailings pond dam that will be 190 meters high? That's the seventh largest dam being proposed in the world. So these are the things that we struggle with. Believe me, my communities know what free, prior, and informed consent is. One of our members asked the president of the mining exploration company, what if our people say no? Because I told him the very first meeting I had with the president said, we need your consent. Our people knew that. So one of them said, what if we say no? And the president said something entirely different. Well, that's not up to me. That's up to the government. I'm sorry, but free, prior, informed consent applies to you, company. So I really appreciate Chief Laceese and the comment that he made with respect to the free, prior, informed consent agreement with BC and Taseko Mines. In the Canada's action plan, you will not see the word redress in there. Actually, the word redress is in there, no reference to Article 28, and there's no references as to how you evaluate lands and resources that have been taken or that are still, say, timber that is still standing right now. What is a valuation process for this? And there's a fair amount of work that's got to be done underlying this, but both governments do not want to deal with it. But Aboriginal title exists, and the beneficial component, the beneficial interest, is that right of any government to extract benefits from the lands or territorial resources. And that beneficial interest is absolutely critical in the process of valuation. So I don't really want to say much more than that. I think a lot has been said, but I think that the last thing, knocking on the doors, as Kenneth was saying, is that we've been able to make progress when we work together, when we have discipline. I remember all of the meetings in Geneva and the high level of discipline that a wide range of Indigenous peoples who gathered there every year, well, not every year, but periodically during the negotiations of the UN Declaration, but there with the support from the non-governmental organizations who understood a lot of this work. And you cannot beat that. It's so essential to our work. And together to bring forward the friendly states, there are many. In British Columbia right now, because of court cases, we see opposition parties, the conservative far-right thinking is that they want to rip up the UN Declaration, for example. And, there is an existential threat there for us, as we saw in 1870s and 1850s when all of our lands were taken by colonial authorities simply by one proclamation. I wanted to share those with you, and please share those documents. There's far more at the back end of both of those documents are a series of recommendations that really fully are in accordance with what this seminar and this webinar is. There's a lot of thinking has gone into those as we move forward. So for the full and effective implementation, Lea, as you say, of the declaration, the challenges are still there. We have the rights, we have the freedoms, and we have the responsibilities to understand what those responsibilities that we have to the future as outlined in Article 25. But for the purpose of the Declaration, Article 43 is for the survival, dignity, and well-being of Indigenous peoples. That's us. How do we use a declaration for that particular purpose as outlined in Article 43? Thank you, Lea, and thank you to all of you for the tremendous wisdom that you presented today.
Oh, thank you, Grand Chief, for really weaving all of that together. That was really great. Thank you for mentioning responsibilities. I'm sure my mother would thank you for that as well. She always reminds us that that's what it's all about. I also want to thank you for talking about the spiritual and cultural component of our lands. And, the idea, we really have to wrap our heads around the idea that redress is going to need to not only look at that economic value of, say, development, but really at culture and language loss tied to our lands and territories. So I really appreciate all of that. Now we've got a bit of time left to do a Q&A, and I see that there is. Oh, first, I also wanted to note, Grand Chief, that the links are in the chat for the two papers that you shared, and Dr. Lightfoot will send you those by email as well, just to make sure you can download them. I do see a question from Darren Brown. Hi, Darren. He's saying, many thanks, Dr. Lightfoot. The line cooperation and collaboration is in a space of mutual respect produces results. He said that was pointed and wise. One can confidently say an international trade agreement that specifically names and respects the rights of Indigenous peoples is a concrete developmental result. He also mentions Grand Chief Edward John cites responsibility many times in an area as what is being called the polycrisis. So the question here, though, is how can the declaration be best leveraged to advance and amplify the voices of Indigenous peoples in responsibilizing discernment and decision-making processes in a space of mutual respect? Sorry, Darren, I'm paraphrasing you. So is there anyone who'd like to address that question?
I can take I think I'm on, am I?
Yes, you are. Go ahead.
Yeah. Well, in our case, Glasgow Nation, we have two communities. What we decided to do is to exercise the rights in the declaration. The free, prior, informed consent, the right to make decisions as peoples and as governments, the right to protect whatever we have, the right to our languages. We have plans in all of these areas using the UN Declaration as a foundation, because we don't see a lot of, we have federal legislation that's premised on the UN Declaration. We have federal legislation, on language, we have federal legislation on child welfare. Those are premised on the inherent rights that we have. So what we've said is we will exercise these rights that we have. See, the UN Sustainable Development Goals 2030 talks about leave no one behind. And it says also the principles behind it also say reach back to the ones furthest behind. Well, in my communities, that's where we are. We're behind, and we're also furthest behind. that in our assessment, that's what we see. And that's what we want change, and we want to use this instrument and other instruments to help us move beyond that. Is just for us to exercise the rights that we have fully and effectively in the face of opposition. We have governments, officials who come to our communities who don't understand the UN Declaration, nor are committed to even using the words UN Declaration, but we have to educate them. We have to let them know where we stand. So we rejected in our proclamation that we issued, we rejected James Douglas's proclamation of February 14th, 1859. And we issued our own proclamation that's on October 4th, 2024, that says this is what we will do, and this is how we will engage governments, and this is how we will engage industry and the public. So it's a public document we put out there, and we're just saying this is who we are. This is how we're going to move forward. And thank you very much. But we have the solid support. You mentioned the International Law Alliance report. There are two reports that were produced when Daley Sambo Doro was on that body, and one of them is that free, prior, and informed consent is part of international law, part of customary international law at minimum, because that idea of self-determination and the idea of free, prior, and informed consent weren't created by us. They were already in other international instruments and conventions and treaties. And we borrowed those ideas and incorporate them into the Declaration, saying that we are peoples and we are no different, Kenneth, with the letter S at the end of people. We're peoples, not populations, and these are what we will stand on. So maybe thank you for the question. I'm hoping that at least from our perspective, this is what we're doing. We make no apologies to anyone, and we don't ask for any quarters to be given. If they don't like it, well, that's too bad. That's what we're going to do.
Thank you very much, Grand Chief. I actually have a few other questions. And first, I'm wondering if, Kenneth, Dr. Deere, can you talk about the importance of being at the table? I mean, you talked about Deskahe seeking to speak or be part of, in fact, the international system. And so could you talk a little bit about the work that you're doing in that regard?
Yeah, thanks, Lee. I'll try. When this guy went to the League of Nations, all he wanted to have was a voice to be able to address the league and let them know the situation that our people were in, and then that was denied. And it's consistent over the years. And even as a young man, people would be telling us, the Haudenosaunee or Indigenous people in general, we there's a seat at the UN with our name on it. All you got to do there is claim it, And I've been going to the UN for decades, and I've never seen a seat with our name on it. But that was the culture, the feeling that our people were sovereign and we have a voice and we have a place in a place like the United Nations. So we're and we also in the debates on the World Conference on Indigenous People to participate or not to participate, Oren Lyons said it very well. He says, if we're not at the table, you're on the menu, and the United Nations are going to be talking about you. You better be there to speak for yourself. Don't other states can't speak for us. We have to speak for ourselves. And we can't depend even on friendly, quote unquote, friendly states. We can't let them speak for us. We have to speak for ourselves. So right now, we've been fighting in the World Conference outcome document. We talked about enhanced participation for Indigenous peoples. Indigenous peoples on the outcome document said that we wanted permanent observer status in the United Nations. So we're still fighting for that since 2024, no 14, fighting for enhanced participation. What we call permanent observer status, and we've been it's the states are pushing back hard against that because they don't want to recognize us as governments. We are not NGOs. We are not non-governmental organizations. We are governments, and so we have states supporting us. We have states against us, but we made small gains in Geneva at the Human Rights Council, where on 3 agenda items now we have observer status in agenda, the three agenda items that deal with Indigenous peoples, the interactive dialogue with the MRIP, interactive dialogue with Special Rapporteur, and the half-day panel discussion. Those three agenda items, we now have a status called observer status, where states speak first, and then Indigenous peoples with observer status, and then NGOs. So that was a step up. We have for the first time ever at the Human Rights Council, there's a chair there that says Indigenous peoples. And that's the first time that's ever happened at the Human Rights Council. The Human Rights Council is a state's body. It's a state's meeting. So it's not like the MRIP where they do have that or the permanent forum, but the Human Rights Council there's 2 seats or 4 seats there actually for Indigenous peoples, and that's a step trying to get Indigenous people recognized as governments. So we're working at that. I don't know if that answered your question, but that's where we are right now.
That's excellent. Thank you, Kenneth. We have a couple more questions in the chat, so I'm going to go to Sherry Helgeson first, who's talking about the National Action Plan. And she's talking about how there's the first plan will end in 2028. And when it's being renewed in consultation and cooperation, what aspects do you think will be the most important to focus on? And I'm going to say monitoring mechanisms, but I'm going to invite the board or the members that are here today to. Is there anyone who would like to take this question? Sheryl.
I will pick it up and just pick up the thread that you started, Lea, about the importance of monitoring mechanisms. This is not really addressed in the first action plan, and we haven't seen the creation of it during the time frame. Now, of course, every year, British Columbia and the federal government put out their reporting on their progress on the National Action Plan. And I'm presuming the same thing will happen in NWT over time. Now, that's wonderful, but I think we can all agree that self-assessment is only step one in actual monitoring and evaluation and improvements. So, we all have our own jobs. We do a self-assessment first before we go into an independent review of some kind or a multilateral review. So we know that this is a proper way to do evaluation, monitoring, and assessment. So we need to move forward on this. It is specifically mentioned in the declaration that independent monitoring mechanisms are required. So I think a priority moving into this next phase is that we establish that both federally and move further on that in the provinces and territories as well that have national action plans. And then also for New Zealand, when they eventually get their national action plan up and running, I would like to see them put independent monitoring mechanisms on the table in the first round.
That's great. Well, thank you, Sheryl. And speaking of really, really smart young people, there's a question here from Sage Goodleaf. And hello, Sage. Nice to have you with us today. So she said that the UN Declaration emerged from decades of Indigenous advocacy within international law spaces that were not made for us, as Kenneth was saying. What advice would you offer to Indigenous youth entering these same spaces today to continue transforming them while staying grounded in our own laws and teachings? I don't want to pick on anyone, but I'm wondering if Chief Francis, do you have any thoughts here about young people working in this space?
Thank you. Yeah, I think it's really important that our young people, no matter where they are, get involved and learn about all the human rights that they can. As an example, there's different lawyers, but I think if they can pursue their interest into becoming a human rights lawyer, for one, and I think there's just the perception from the government and industry that everything is just there for the taking, disregarding our Aboriginal rights and title and our human rights. And I think that a lot of our youth are taking that step, into attending these forums, and at the same time, we're making alliances with all the other nations that attend from across the world, and I think that's very important. To learn from each other and to work together. Um, and I think that's happening in some ways, but I think with the more involvement with a lot of our youth and a lot of training of our youth and different nations that are becoming aware of the UNDRIP and human rights, I think that's just going to keep expanding. With I think there might be different courses and whatnot that should be offered at certain levels of education. I think would really help. And I think just for the youth to be really grounded and really learn their culture and their language for one, that's a big help. And ceremony is important. So I think those are a lot of them are doing that, and that's I think we're going to be a lot of young people that are going to be strong and taking over, some of these positions that you're talking about, and some of them have been created, and some of them might be still going to be created. And I think they have some pretty strong ideas, and that'll be a big help. Thank you.
Go ahead. Thank you, Chief Francis, and go ahead, Kenneth.
Yeah, thanks, Leah. And I have deep concerns. I'm not. I have deep concerns about who's going to be replacing the people that have been there, like myself and Ed John, and been there for a while. And I was a young man when I started all this stuff, and all of a sudden I got a little old, just a little old. And I'm impressed with some of the young people. Leah, you're one of them. I appreciate the work that you do and stuff, and others here on this. I know Naiomi and everybody, Sheryl, everybody's the work that you're doing. And but when it comes to the international work, there's nothing beats experience. You got to be there. You got to be in those rooms. You got to be, you can only learn so much in a classroom. And if I can go to a university and tell all this just great stories, I guess, about the struggle. But unless you experience it, you don't know what it's really like, and you have to be. Right now, we have a gang of people in COP 30 in Belém. I'm following them on WhatsApp and the struggle that they're going through there, fighting for indigenous peoples, fighting against encroachment by local communities, and you'll have to be there on the ground to experience that, and see if you can take it. And not everybody can do international work. You got to be patient. A lot of people have said, "Yeah, I'm going to do this," and then see how frustrating it is, and they said they can't take it. They can't take. They're sincere and everything like that. No, I'm not criticizing them, but international work is not for everybody. It takes a certain character, and you got to have patience. You got to have a thick skin, and I like to see young people out there in the field internationally, and I know that if you bring 10 young people, you might get two that'll stick it out. The rest will be lost on the wayside, or they might come back again in the future. But young people, you gotta, I'm encouraging young people to take international law. We need people that would at the international law level, we've been depending on non-indigenous advisors in the legal field, for years, in decades. We've been and now, they're like Paul Joff, who's now, he's no longer active, and we need who's going to replace Paul Joff, who's going to replace these people that we've been depending on for legal advice, and we need people to fill those shoes. So I'm trying to encourage young people both to study and also to get out there in the field and out there at these meetings, we don't want to raise protesters. We want to raise negotiators, people who can negotiate. That's what we need. All right.
Lea,
Go ahead.
thank you. Thank you to young lady for the question, and I agree with both Francis and Kenneth on the comments that they make. Understand and participate at these international levels. Some of it may be a bit bewildering. My wife came with me to Geneva once and went to the discussions up at the main hall, and by noon she said, "I can't stand this. You're arguing about to cross which I to cross and which T to cross, and everything that may be trivial, whether the letter is at the end of the word people, so it become peoples. Why is that important? Those sorts of things or the capitalization of the word indigenous and the word peoples. These are small victories for our people in the face of the tremendous levels of opposition. But what I wanted to say is what Francis said and support what Kenneth said, was that before I even went to an Indian residential school, I was raised up till around age 8 in my communities with elders who only spoke our language. My communities were completely bilingual, not bilingual in the sense that they were all bilingual. Most of them spoke only our language, and I grew up with them. And I lived on the land with them, traveled on the land with them, on the waters. And what I learned there from the language and understanding, being fluent in the language, is a strong foundation that if I sat down with the UN Secretary General, I can be absolutely confident of who I am and where I come from, because that's how I was raised. That level of confidence and that level of knowledge about our peoples, about our history, about our cultures and our beliefs. I went to UBC Law School, and there's a principle in property law and about a riverbed. If you own the riverbed, then you own the fish that swims in the river. And so I went back to my community and to the elders. I sat down. I said, "They wasn't a you so cha." I said, "These people, this is how they think: is that if you own the riverbed, you also now own the salmon or the fish." And they said, "Senna, how could they think like that? Because ours is not based on the book of Genesis, that we are the masters of the lands, that we are dominion over nature. Ours is completely different. It's a level of and teachings of coexistence with everything around us, the mountains, the snow, the fish, the birds, all of those animals that Kenneth Deere was talking about, the relationships that we have, the distinctive spiritual relationships what we have is absolutely key." So to the young lady who asked the question, I think it's really important to make sure that that part of the learning, traditional knowledge, is really that you're really securing it. Really, that the authentic knowledge. That lots of people make up stories, and you have to disregard that. You have to look for the authenticity behind the stories that we have, and I think that's really important foundation to be able to sit with any world leader, or even not leaders, common people across the world, or in the non-native communities. So thank you, Lea.
Well, thank you, Grand Chief. And I think you went part of the way in answering, or quite a long way in answering, Michelle Edwards' question about self-determination and looking after our resources, including salmon. But I'd like to give Naiomi the last word about this issue. And sorry, West Coast Pacific salmon folks, but we're East Coast Atlantic salmon. So, Naiomi, can you answer the question about having a say in the management and allocation of salmon?
Yeah, I mean, we're from Listigouche, we're Salmon people. I mean, looking at the question, I absolutely think that we need to be implementing UNDRIP as much for ourselves. And I think I remember Sage Henderson, who was also part of all of this work. But like that was the biggest, one of the things he always says is that is one of the biggest things that why he was doing and why other people he talked to were doing it was so that, this document is as much for us, right, in terms of our implementation of it. And I think that that is so important in terms of the implementation of the self-determination and self-government. But with that, the revitalization of our laws. So kind of going back to the answers to the last question. I mean, that has to be, it's so key as part of the declaration, right? So many articles, 534. I mean, they're all referencing our institutions, our knowledge, our laws, all of the, maybe we don't always call it that, but our worldview, our language, our cultures, that all inform how we see our responsibilities to each other and the world around us. And that is so key. So UNDRIP brings that in. And I think that, coming back to that idea of braiding is so important. And maybe kind of weave the last two questions. I feel I gave a talk a couple weeks ago, and it really is a bit of a balance sometimes in all this work that we do as Indigenous people and advocates between fighting for recognition, by states and the international domain, and on the same time doing what this work is really about is revitalizing and working with our ways of knowing and do what. That's why we're doing it, right? Is to safeguard and protect and revitalize that knowledge and those laws. And we can't lose sight of that. Like, you kind of got to do all that recognition work, but you can't lose sight of that fundamental work that really informs who we are. And it's a hard balance, and I don't always get it right. And I think many people struggle with it, but you kind of have to remember that the reason you're doing that work is to, come back to who we are as a people. And not to say we can't evolve in various ways, right? Like any other peoples, but, we're doing this because of, who we are as peoples. So thank you.
Well, thank you very much, Naiomi. And just to call out one other person, Dr. Wilton Littlechild, who's also a member of the coalition, often speaks of the sacred nature of our treaties, and also that our treaties affirm the rights that we already know that we have. And even if they are broken, they still remain the law of this land. So I see that there's another question about redress. Unfortunately, we're not fully going to be able to get to that. But as Grand Chief has given us our marching orders in terms of Article 28 regarding redress at the permanent forum, both doing a study and an expert table, keep an eye out for that. We'll push for it. And thank you for that direction, Grand Chief. And so thank you to all of you. My heart is very full right now, and I'm just so delighted to be here with you and so honored to be asked to. Oh, Kenneth wants to say something. Last word goes to Kenneth.
Oh, no, nope. That was an accident. Sorry.
Oh, okay. Well, thank you, and you can have the last word if you want it. But otherwise, I will thank you, Willie, to everyone, and have a wonderful, wonderful rest of your day.